Okay, welcome to our next training session, our Wednesday morning training session. So today we are welcoming Phatheka, who is a conveyancing attorney. And the reason why she's coming along, first of all, she's a conveyancing attorney, so she knows what she's talking about. And today we are talking about the offer to purchase. But a second reason is because I think a key part of our success is to build those relationships with key stakeholders in our business, which can then help us, perform better. And one of those key stakeholders is having a good conveyancing attorney on your side. As I like to say, a good conveyancing attorney who are on call. I've got a quick question. I've got a quick query. Can I phone someone who's an expert? Some of you sometimes call me, but I think sometimes it's better that you call your own attorney on tap or on call, who can then answer and give you your query, 30-second answer to your query. We're not talking about taking advantage for 2-hour consultants session. We're talking about a quick call or email. And someone like Phatheka is specialized in that. She's here to build relationships. She's here to serve us. And obviously, over a period of time, she can then gain our service and gain business from us. So that's one of the reasons why I just want, part of today is introducing ourselves to her. She will, over a period of time, be in touch with you. I am giving her your contact number, and that's the Chorus team members. Those that are signed on with Chorus and EXP, those that are not yet signed on, obviously not sharing those details, the email addresses and cell phone numbers, and she may be in touch with you just to keep in touch, so that when you do have a query, that you have someone to call. Okay, and please do support her. Okay, I don't dictate in our team as to who we use. What's critical for me, if you don't have any relationship, then I would highly recommend that you use someone like Phatheka, because that's going to give you your service. But what I am really pleading for you to do, is recommending, is that you build a relationship. And if your existing conveyancing attorney relationship is not a solid one, in other words, they're not here to support you, they don't give brilliant service and quick service, then please move or recommend someone else to your sellers. Okay, that's enough for me. Here, Phatheka, please go ahead, and we look forward to hearing from you.
Thank you so much, David. Thank you so much, and good morning to everyone. My name is Phatheka, a founding director of Phatheka Maliphale Incorporated. We are based in Johannesburg, and we specialize in property law, which is conveyancing and property development. So that is our specialty, and we also do a bit of commercial. I'm also a notary, so I also do some notarial work, that is authentication of documents, as well as anti-nuptial contracts and registration of trusts. So I also deal with a lot of property investors. We mostly look at property portfolios, how to structure, and all those kind of things. So we are in the property field so much that the most important thing again is when we go out there with seminars, we also, as David just mentioned, preach the fact that there must be a team, there must be someone within your team who is at least someone that you can highly recommend, someone that can be able to give you the services that you are looking for. And then again, the most important thing is you need someone whom you understand the credibility and that person's track record, because I can say to you that there are many times where I get approached by clients where they have appointed conveyancers, but they never do their due diligence to check if the company is indeed a conveyancing company and that they have a conveyancer in place. So it does happen. So it's also important to obviously have those kind of relationship with that person that you have done a due diligence and understand that person that is indeed a practicing conveyancer. So today, what we are going to be talking about, we had a chat with David regarding the offer to purchase. As David also mentioned that it's always important to have that person on a team whereby you know this person is going to be my go-to person. Go-to person in the sense of if there's a quick question about the offer to purchase, then you are able to just contact that person and get clarity, because I always believe that that is what is important. So how do we stand out from other conveyances? I think my advantage is that I was a conveyancing secretary for more than 10 years while I was still studying, and I have a deep understanding of the conveyancing transactions. So for me, what I have realized is that most of the time, the deals sometimes which are not proceeding is because the deal was not concluded properly from the onset. So during those initial stages, when we are negotiating the deals with the parties, that's where maybe we miss something there, and then that would result in the deal maybe, or result in issues or result in disputes. So for me, it's always important to have a conversation in the early stages before the OTP, so that we can all know that if there are issues, we obviously deal with the issues before any person can put a signature on the dotted line. So that's how we are standing out, because we do not want a situation where we're receiving an instruction and again we have to deal with the disputes or the issues that are within the transaction, kind of like avoiding that. Okay, so getting to know your OTP, then that's where it starts, because this is your initial stage. This is where you are having that OTP. Obviously, I know that we can't, because OTPs most of the time are more than 10 pages, and most clients, they do not read all the pages. And the most important thing is for us to know the actual clauses that are always bringing up issues. So what I did then is I picked up a few of those. I know that they are the regulars when clients are calling me to get some clarity. So again, the most important thing for us is obviously the quality of that transaction, because the quality of that transaction will determine the fast turnaround times, and also will obviously help if we do it in the initial stages, that we also have those solutions, because we have to bring those solutions at the early stage, so that we should know if the seller is going to have issues or the buyer is going to have issues, then we prepare ourselves for that. So the most important thing again is to bring that solution. So that's what we are bringing, is the solution to make sure that there are no issues within the deals. Meaning, if there are issues, let's deal with them at that stage, at that initial stage. Okay, so concluding an offer to purchase, what is our role as the property practitioners? So again, the OTP, as I mentioned, is more than 10 pages most of the time, and the terms of the offer to purchase, yes, because most of OTPs are standard OTPs, and being standard, obviously the most important thing is to make sure that you understand that there isn't anything that is going to be misinterpreted in any of the terms of the contract, as standard as it can be. And then also to pinpoint the most important clauses from the OTP, whereby I know that, okay, this clause and this clause, then I can be able to explain to the client, and the client won't have issues then going forward. And also to understand the irrevocable clause. So this clause is always an issue, especially because it's not your fault as a property practitioner that the parties are delaying. You obviously had a plan that this OTP must be accepted within 5 days. And then it does happen that the client accepts it on the 6th day or the 7th day. And then if it does happen and you already put a date in the OTP that it must be accepted within this period or before this date, then it is important to make sure that you cover that. Why? Because this irrevocable clause, should there be a dispute on the contract, it's easier for the other party to say this contract was actually null and void from the onset, because they know that it was accepted after the effect. So you can't, because obviously we always say when we interpret the clause that you can't revive something that is already dead. So if it's accepted, because you put an offer for it to be accepted, once it's not accepted within that period that it was given, then it means that there's no offer on the table anymore. So that is why it's important to always look at that clause, so that should there be a dispute, you don't get caught with a situation where someone is going to be like, in any case, this OTP is null and void because it was accepted after the effect. So just to try and avoid that. And also the intention of the purchaser. So because I'm dealing with a lot of property investors as well, so I always ask them as to why are you purchasing this property, so that at least I should know that they are not buying something, because people can get excited and then they can just sign. And then in signing, they will obviously try and okay, not to say to try, they will obviously miss some other things, and then missing those things, the most important information actually is it's very important to be the one posing that question, why are you buying this property, so that you should have an understanding, and also to try and advise that client that, okay, this property is going to be suitable for what you are going to be purchasing it for. And also it will help you to know what are the documents that the purchaser will be asking. For example, the rezoning of the property is correct, and also the building plans and all those kind of things, so that you should know that those are the things that are going to be required upfront. And also because you're representing the seller, then the seller will obviously advise you that there are plans or there are no plans, or whatever the case, so that then you can prepare yourself and also prepare your purchaser, so that the purchaser should know while signing that there are no plans in place. And then, is the seller a foreigner living overseas? So again, for those that are living overseas, the most important thing, besides the fact that their documents will be signed, if there's no special power of attorney signed, to have someone acting on their behalf in the country, then it means that should the property be sold for more than 2 million, then it means that there's going to be a withholding tax applicable. So those kind of things, again, is the things that we need to inform them at the very early stage, so that they should know that there is going to be a percentage that is going to be withheld as a requirement by SARS. And then they can prepare themselves early actually before the signing of the contract. And also the existing bond statement. I know most of the time, property practitioners, they do ask, and the sellers sometimes they do not provide. But I think the most important part about this bond statement is just to make sure that this property is not sold for a loss. Because again, it's all well and good to have a contract signed, get excited, the deal is sealed, and yet when we proceed with the transaction, we find out that there's a shortfall in the property, and then that shortfall again, it doesn't mean that it's not something that can be sorted, because I do have a few matters currently that they have a shortfall where I'm busy negotiating with the bank, so I can have an acknowledgement of debt signed for the client, so that the deal can proceed. But the most important thing is, because clients obviously they don't understand that can obviously delay the whole process, because of the fact that we still have to, because it has to move now from one department to the other within the bank, so that we can be able to negotiate and have the bank approve the shortfall, because it's kind of like an application, and then it has to be approved so that the deal can then proceed. And then lastly, the 90-day notice. So 90-day notice is obviously, because I think a lot of sellers, they always have in their minds that should I notify the bank is going to penalize me if the property is not sold, which is not the case. So they will obviously not be penalized. The most important thing is just to make sure that they do inform the bank, so that there is no penalty, because there's a penalty if you do not inform the bank. So they have to inform the bank. And also, I know some clients, they always want to wait until the 90-day period lapses before they can proceed, because they are trying to run away from paying for that penalty. But again, if they inform the bank earlier, then because usually the transaction takes a maximum of 90 days. Although if it does take earlier, if if the period becomes shorter, let's say 60 days, then again, they will know that there is going to be that provision for the penalty. Although again, the penalty is calculated pro rata by the bank if the transaction didn't take the 90-day period. And then moving now to to the conveyancer. So now you are instructing the conveyancer to deal with your matter. So the most important thing for us in our offices is to check if the parties have contractual capacity. So having contractual capacity, again, you don't want a situation, because I've had cases where people are selling properties and yet maybe they're not even appointed by the Master of the High Court to deal with the property. So they don't have authority at all. And then also finding out that the person who was actually selling the property, selling it on behalf of someone else, just because they think that they were supposed to benefit as a child, maybe from the father or the mother's property. And again, it happens that the Master of the High Court process was never followed. So again, it's important that if for example you get kind of a transaction, to ask the client if there's a deceased matter, to ask the client if the deceased estate was reported with the master, so that then you should know there is a letter of authority or there is a letter of executorship. Because it does happen that, because for example, there was a matter where there was a dispute, and then we found out that this person actually signed the OTP before he was appointed. That then declares that contract to be null and void, because that person didn't have authority. And then communicate the terms of the offer to purchase with the client. So in our offices, when you acknowledge receipt, then we have to obviously kind of inform both parties, that is the seller, the purchaser, including the property practitioner, about the most important terms within the contract in which it requires each party to comply. And then also ensure compliance by both parties. That is compliance, again, it is to do with Phatheka, it is to do with providing for whatever documents that are required, it is to do with your bond to be approved within the normal time, those kind of things. And then also a resolution. So again, I know that we deal with most of the time those resolutions when we receive the instruction, yet the resolution must be signed before that person signs the OTP. So if you are acting on behalf of a company, if you are acting on behalf of a trust, there must be a resolution in place that authorizes you to sign the OTP. Otherwise, if you are not authorized, because now sometimes you find out that I have to draft that resolution so that you can, but the problem is I can't backdate it, can't backdate that resolution. So that is why then it has to be signed. For example, you can call and say, Sispet, I've got someone who's acting on behalf of the company, but they don't have a resolution. Can you please share precedent? Then I can quickly email it to you, and then you can get it signed, because obviously I can't backdate the resolution that needs to be signed, and they can't sign the OTP without being authorized to do so. And then the purchase price. So the purchase price again, which is going back to the previous slide, the bond statement. Because when we receive the bond cancellation figures from the bank, then we obviously have to check, okay, he's selling the property for R5, he's owing the bond, owing the bank R3, now we are left with R2. From this R2, there are rates, there are levies, there's agent's commission, there's compliance certificate like your electrical compliance certificate, gas, and all these other ones. So just to make sure that everything will then be covered within the purchase price, there won't be a situation of a shortfall. And then moving to the factors influencing the turnaround time for a transfer. So that 90-day period, yes, it does affect, because most clients, sometimes they would want to wait so that they can have that penalty waived. And then the dispute on rates and levies. So it does happen that most of the time, a client, for example, you will find that the municipality has got a water account, it doesn't have rates, or it has rates, it doesn't have a water account. Well, we need to sort that thing out, because again, if we transfer the property to a new buyer, we don't want the new buyer to have problems with regards to opening a new account. So we have to sort out that issue before we transfer the property. And also dispute on the special levy. So again, on our contracts, if it's a sectional title property, just to make sure that you know if there will be, because the seller will tell you, but most of the time sellers, they don't want to disclose that, or maybe they don't even know, if maybe because they never attended the AGM of the body corporate where the special levy was raised. So it's important to also know if there is that special levy, so that we should know. I had a situation where the purchaser was like, no, I am not paying any special levy. That special levy must be paid by the seller. Why? Because the contract didn't make a provision for that. So the special levy, then it has to end on date of registration so that the purchaser can be able to take over with that special levy, because special levy is for the improvement of the sectional scheme itself. So meaning that it's a benefit for the new buyer. And then the conditional clauses, again, those conditional clauses, so we do put them in our letters of acknowledgement so that we make them aware that if you are not complying on time, you obviously are going to be contributing in delaying the process. Again, the issue of a non-resident or the seller who's a resident but residing outside South Africa. Again, those issues of the special power of attorney, the issues of having documents signed within their embassy, wherever they are. And then again, the most important thing I think is important is to have a special power of attorney for that person, so that documents can be signed by whoever is appointed within the country, so that we don't have a situation where we have to tell them that, you know what, you need to go to a certain embassy, have the documents notarized, and then it becomes a lengthy thing and clients get frustrated. And then SARS transfer duty and VAT receipt. So again, what delays the process here is if SARS has issues with regards to the tax, because obviously we have to inform SARS that the property is now sold, and then they look at the individuals who are selling the property to see if there are any outstanding taxes or something like that. I do get letters from SARS because they are authorized in terms of the law that they can instruct me and say, Phatheka, there is an outstanding amount with respect to the seller, so can you please deduct from the proceeds to pay? Again, if the seller is not in agreement with that, it delays the process, because I can't just pay, not as much as SARS has raised that. I have to inform the seller so that the seller can be able to go, if the seller has a dispute, actually can go to SARS and have that dispute resolved before I can. Because on my side, because I've received the letter, then the law says I have to pay. And then electrical and gas compliance certificate. I know that most sellers, they actually the buyers now are trying to change that, because buyers, they want to use their own electrician if the seller and the property practitioner don't have anyone recommended. And then again, if there are issues, because there are things where, for example, clients sent me photos of hanging plugs, whereas a compliance certificate was already issued. So again, those kind of things are the things that I cannot register a property whilst they are hanging plugs. I have to make sure that that is sorted. So again, that electrician must be a registered person, so that the buyer can be able to make reference, because the reason why a certificate is issued is for the security of the buyer, so that the buyer can contact the electrician should there be a problem, because the issuing of the certificate confirms that everything is in order in the house. And then again, the restrictive conditions on the title deed. I know most of the time, if there's a bond, obviously you won't see the title deed. We will only see the title deed when we request it from the bank. So if there are those restrictive conditions, going back to the previous slide, I mentioned that you can ask the purchaser what's the intention of buying the property, so that within that intention there is no restrictive, not as much as, again, it is the buyer's responsibility to do his or her own due diligence. So that she should know, if I'm purchasing this property for multi-let or whatever, there are no restrictive conditions that will restrict me from doing so, because again, that contributes in the delay of the process. Okay, and then moving to what is it that we can expect, when to expect delay. So if it's a deceased estate transfer, what I would like to highlight is that remember that if a person is selling a property from a deceased, it's either the beneficiary is the one selling, or the executor is the one selling. So if it's a beneficiary who's selling the property, it's fine, because the beneficiary will receive the property. So meaning it's going to be a back-to-back transfer. The beneficiary will have the property transferred in their name, and then they will sell it. So which is fine, because I don't need an approval from the master, therefore. But If it's a sale by the executor then needs to still go back to the master and get the master to approve the sale. That's where the difference of the deceased estate. So now the problem with the approval, which causes the delays, is that it might happen because if the executor is selling, the estate does not need to be fully wind up, for example. You can sell at any period within the winding up of the estate. So that executor then needs to go back to the master and get the master then to approve the sale. If then, because you don't have to wait for the winding up, the master is of the opinion that no, I haven't seen the L&D account actually. So can you please provide me with 1, 2, 3? They will obviously list whatever it is that they need so that they can give themselves some assurance that every party who's interested in this deceased estate is not going to be prejudiced. They will list whatever it is that they need. So the delay is in that. Unless if, for example, you are selling the property once the L&D account is already approved, then that makes it easier. But if it's not approved yet, then there are certain issues, certain things that the master would want to firstly confirm so that they should know that there is nothing that is kind of dodgy in terms of this sale where you're excluding certain parties that are supposed to benefit from the sale. And then if it's a beneficiary, then the beneficiary will obviously first take the transfer and then immediately then transfer it to the new owner. And then insolvency transfers. Insolvency transfers are not even the popular ones because I see that not everyone is becoming insolvent. So I think I dealt with 1 or 2 like in the years early in the years of my admission, because the delay here is we are dealing with the trustees and there's a master of the High Court again. So it becomes like a lengthy process again. And then the divorce transfer. Divorce transfer, it also depends on who sells the property, because it does happen that the party who sells the property maybe is the one who is entitled to the property in terms of the divorce order. So it's important then as a property practitioner to ask for a copy of the divorce order and the settlement agreement so that you can see that, okay, because for example, I had a matter where the lady said, no, I'm entitled to the property. Then we said the court order says that there's a settlement agreement. So we need to be sure because we need to submit that settlement agreement at the deeds office. So therefore, we need to see that you are indeed entitled to this property, because it does happen that sometimes the person who's selling the property is the other party who wants to be bought out because of the divorce settlement. Because if the court says you are both entitled to the property and then obviously the other party doesn't want to sell and I can't just be stuck in this bond, I need to have this property sold. And then some people would just go and market the property, get some people to buy, and then the other party then refuse to sign. Those kind of things. So when it comes to a divorce transfer, when a person says I'm divorced and I'm selling this property out of the divorce, then we should ask for that divorce order and then ask for that settlement agreement just to ensure that indeed this person is entitled to this property. So there won't be any issues with the other party with regards to the sale of the property. Okay, and then what are these frequently asked questions that I usually receive? So the suspensive conditions. Okay, the suspensive clause, if you check on the OTP, I've seen it in your OTP as well. It does say it is for the benefit of the purchaser. That is why it suspends the operation of the contract. So when I receive an instruction with a suspensive condition, it means that I can only acknowledge receipt with all parties, try to clarify all the terms in the contract, and it ends there. I can't request for levies, I can't request for rates or do anything until the bond is granted, because of the nature of that clause, because that clause suspends the operation until such time as the bond is granted. So once the bond is granted, then it means that we are back to business again. Then I can then proceed to request bond cancellation figures, request for rates, request for levies, and anything else that I need to do in terms of the contract. So that is the most important thing about that suspensive contract. That is why, again, if you see that, okay, the purchaser is actually being delayed in terms of the application of his or her bond, then what you can do, you can quickly, if the contract does not make a provision for an extension, you can quickly speak to the seller and ask the seller to grant the purchaser an extension of time, depending on whatever the time. And if it's granted, that's when then we draft an addendum to extend the period. Because should it not grant it within that period, that OTP lapses, it becomes null and void. So to avoid that is to do an addendum to extend the period if the purchaser is obviously being delayed by the banks in terms of the approval of the loan. And then obviously, yeah, I've also touched on the extension of that bond grant and the addendum on the amendment of the sale agreement. So those addendums, it's not only for suspensive condition, obviously. So addendums, if there are any things that have changed, for example. So it does happen that, for example, the person goes and views the property, and then if the buyer goes and views that property and he sees and he loves the property, and then he goes again as part of maybe his or her due diligence, he goes there to go and check something, and he realizes, oh no, actually there is this and this and this and that, depending on the negotiation then with the parties, then that's when we can also draft addendums as part of the terms of the contract. And again, resolutions where the seller or the purchaser is a legal person. Again, it's important to have those resolutions before they sign the OTP, because those resolutions are giving them authority to sign the OTP. So authority, that is the authority to sign or deal with the property. Also on the deceased estate, I also mentioned that on the deceased estate, there must be a letter of authority or a letter of executorship, because those letters are important for you to know that this person that you are dealing with is actually the person authorized to deal with the property. And then the Hertford Coop clause. So this one, I know that in most cases, people when buying properties, especially for investment purposes, the property is already occupied by the tenants, and then knowing for a fact that you can't, as a buyer, you can't buy that property unless you want vacant occupation. So if you are buying it for investment purposes and there are already tenants in the property, you need to know as a buyer that those tenants will still stay in that property until their leases expire. So meaning you can't think that, or the buyer can't think that they are going to, as soon as the property is registered in their names, they are going to quickly change everything. When I mean everything, I mean they will change the lease agreement and its terms. So the lease agreement as it stands, then they will have to go with those lease agreements, because that Hertford Club clause, it says that the tenant has more rights than the seller. So it's important then to explain that to the buyer, that buyer, you are buying for investment purposes and there are tenants in the property. Are you going to take over the tenants? If the answer is yes, then they would obviously request for copies of lease agreements so that they can see how much are they paying for rent, and also when are the lease agreements expires, so that they don't have a situation where the lease agreements maybe are very new and they will have to obviously carry that lease agreement for a period of 12 months before they can decide to renew the lease agreements. So that is the most important part about that clause, is that those, unless obviously the buyer says, no, I want vacant occupation. Then if they want vacant occupation, again, we need to make a provision on our OTPs that the tenant will be given a notice to vacate, so that the tenant can vacate, so that on registration there are no issues. Because again, our offices can't register a property where there's supposed to be vacant occupation and then the tenant is still there. I know because I've got one again that was registered last week where the tenants are still there, but the transferring attorneys, because I was just doing a watching brief on that transaction. Then we requested the transferring attorneys to withhold a certain amount of money, so that if the tenant are not moving out end of October, then at least we have money to do the eviction, and the buyer was in agreement with that. So it's obviously all upon negotiation, and also to do the negotiation on time, so that we should know I can't just register or allow a transaction to register, knowing for a fact that there is no vacant occupation. The buyer and the seller needs to all agree. If this buyer says no, Phatheka, vacant occupation, then it ends there. I can't register. Unless he says, okay, you can register but withhold certain monies, then again I can do that. So those are the selected clauses from the OTP that I usually get queries or questions, or from clients or from buyers, from sellers, from property practitioners, so that they can get clarity. But the most, again, important thing is just to make sure that we do this from like the initial stage whilst they are negotiating, so that we avoid all these delays due to the fact that people we misunderstanding those terms. Thank you so much.
Thank you so much, Phatheka. Really appreciate it. Well, guys, that's a lot to chew on. Quite a lot of technical details. By the way, please note Phatheka's details on the screen here. I think my first impression is that, guys, especially those that are new in the market and new in the industry, there is a fair amount of legal detail that we need to take, be aware of. And this is why, in the whole, the concept is you've got a buyer, you've got a seller, you've got the terms of the deal, which is typically the selling price, and how's that selling price made up, what's it made up of, and then are there any conditions or suspensive conditions to the deal? In other words, a deal will happen once, there's vacant occupancy, or once there's funding for the deal from a bank or so forth. But there are all these other considerations that can complicate a deal. There's a few deceased estates that have come across my desk over the last 6 months or 12 months, and that's typically delays the transfer by quite a bit. I know Clinton's waiting on that. I know I think Andres was waiting on that for quite a long time. So work with your conveyancing attorney for the details around that. Okay, so please, time for questions. Guys, please ask your questions.
Morning.
How's it,
Marcelo? Morning, Marcelo.
Yes, I would like to know about the divorce transfer.
Yes.
So yeah, because like I walked away from another one. You find that okay, there's divorce, degree of divorce is there, and then the settlement is there, and then it was agreed that the property must be sold, and then they get 50-50. But the other, it was the lady who didn't want to move out. He wanted to buy the man out, but now the challenge was he was blacklisted. She was blacklisted, so that transaction couldn't go through. I don't know how could maybe try to assist in that regard. Because now the man wanted it to be marketed, because the lady is not in a position to can get a loan at the bank. Now, for the property to be listed means both must sign the offer, or even the man can sign, or what, I don't know.
Okay. Are you done, Marcelo?
Yes.
Okay, thank you so much. Okay, so on divorces, what mostly happen, especially if for example the settlement agreement states that the property must be sold, then it means that both parties need to sign the OTP. So the most difficult part most of the time is that the other party, when is refusing, it's because what I usually do, I usually call them to a meeting to try and make them understand, both of them, because obviously we can't hold hostage the other party, because the other party has to move on with his life because of the fact that your credit record is not in good order. Or to get both of them to all agree that, okay, I'm going to give you a period of 6 months in order to try and get your credit rating in order, so that you can be able to go and apply for a loan. Because the difficult part there is the party cannot sell the property alone. So the property must be sold by both parties, especially because the property is registered in both names, unless if they were married out of commit of property. and the property was registered under one party, and it must just be sold, and then you don't need the other party then to sign the OTP. If they were married in commutative property, then it becomes an issue because you need both of them to sign the OTP. So what I usually do, I usually arrange a meeting with them so I can understand why are you worried about your credit rating, and how long do you think that it can be sorted, so that I can be able to convince the other party to maybe give the other a waiting period, let's say maybe a maximum of 6 months, in order to correct the credit rating and be able to apply for a loan.
Okay. No, it means maybe let me try to sit them in a meeting together and
I think we can, yes, I think we can arrange that. Yeah, I think we can arrange that, because sometimes it's just a matter of communicating with them and obviously making them understand that obviously the more you delay, the more it becomes a problem with the other party. So because maybe some clients, they don't even understand the implication of that delay.
Okay. No, I will go back to them, and then if there is an agreement, I will contact you.
Thank you so much, Marcelo.
Okay, thanks.
Sure. Guos?
Morning, everyone. We tend to get the delays with regard to the disease estate transfers.
Yes.
And then the conveyance, they normally stipulate that the issue is with the master's office. That's where they're experiencing the delays. So maybe can you please tell us a bit what's happening at the masters, and why are the estates, disease estate are delayed this much? Thank you.
Okay. You know what, because the master's office is really, yeah, I wouldn't say it's chaotic or something like that, but it's something along those lines, because it's one, difficult to get hold of them, and two, you can send emails and you will never get any response. So out of my frustration with the master's office from way back, so I realized that if you form a relationship with them, it makes your life easier. So what we have done, we have formed relationship with the parties that we know that they can be able to assist us. And also you obviously submit your stuff in a normal way, and should it be delayed, then you can be able to communicate with that person that we have formed a relationship with, so that that person can be able to follow it up for you. So that's what we have done, because we realized that if you don't know anyone there, then it becomes a nightmare. I've been there even in person to try and understand. That's why I'm saying chaotic. I'm using the word chaotic because of the fact that, yeah, you would see files like in their offices, they've got files, a pile of files, and you will see that, you know what, it will take you the whole day even to look for your file. So there's just too much. I don't know whether it's because maybe they are short-staffed or whatever, but yes, there are delays with the master. But again, the most important thing is to form or create relationships with the parties that are working there, so that you can be able to get your stuff sorted quick.
Guys, any more questions?
Hi, Phatheka.
Hi, Pumi.
Okay, I'm not sure whether I logged in late, but then on your slides, you mentioned that when us as the agent submit the OTP to you as the conveyant, you
Yes.
ask the buyer, what is she buying the property for?
The intention.
Yeah, yes. So tell me again, why do you ask that question?
Okay, you asked that question so that you should know if the buyer, because it happens that within the process, then there's going to be delays because the person now realizes that, oh, well, the property is not zoned properly, or is not zoned for whatever the reason why he's purchasing the property for. And then you will find that obviously the rezoning process is a lengthy process as well. So the most important thing about the intention of purchasing that property, in which you have to pose that question, is to make sure that you are not having someone who's going to change his mind along the way.
Okay, I get you.
Okay, and also sorry, ma'am.
No, you can go ahead.
I was saying, and also to help them if they want to do, because obviously buyers, they are supposed to do their own due diligence. So they should know that they need to do that. So meaning you're not going to lead them in terms of what they need to do, but it's just to make sure that you are kind of like highlighting in their minds that you are required them to do your own due diligence.
Okay. Okay, another one. In the process of this sale of a property, let's just say the buyer contacts you and asking what's the delay on the progress. Are you by any means as the conveyance in a position to advise my buyer to look for another property because the property that you are currently working on, it seems like it's going to take a while?
Definitely not. Remember, remember when I receive an instruction, most of the time I receive it from a property practitioner. Property practitioner represents the seller. Or let's say that I receive it from you and the buyer recommended me. So the most important thing for me is to make sure that I execute the contract. I cannot advise the buyer outside that contract.
Thank you so much, Phatheka, for that information.
Thanks, sis.
Guys, good question so far. Anything more? Please don't hesitate to ask something. In your experience, Tembo, Tembo, go ahead.
Yes, another question, Phatheka. I've experienced the deals that fell through with the cash buyers, and they sign the OTPs without stipulating the special conditions. And then those OTPs, they end up in the hands of the attorneys, but the buyers, they don't proceed with the sale, and they don't deposit the required amount to proceed with the purchase. So what is the way forward to deal with those particular buyers? Thank you.
So this buyer is a cash buyer?
Yes, it's cash buyers.
And he's supposed to pay cash within a specific period, right?
Yes.
And then he doesn't pay?
Yes.
Okay, so what happens in that case, which is why I think the most important other clause is the breach clause. Because if the buyer is in breach of their contract, or any party who is in breach of that contract, we have to place that buyer or that person on terms. In terms of, because we're going to be guided by the breach clause. So we have to place them on terms and request them to comply. And then if, for example, the OTP says 7 days, then yes, you're going to give them 7 days to comply. Should they not comply, then the seller would have to instruct me, including you as the property practitioner, whether to cancel the contract or to enforce the contract. That's when then it moves from being a conveyancing transaction to become a litigation transaction. Because remember, a property practitioner's commission is earned if it's a cash sale upon the payment. Upon the signature of the contract. Because if it's a bond, it's earned upon the approval of the loan. So meaning you have already earned your own commission. So therefore, if this buyer is in breach, then he's supposed to pay that commission in full.
Is it worth going for that commission?
Sorry?
What are your chances of getting that commission?
The chances are actually slim, because most of the time you have to waste your own money to try and chase your own money.
So is it just being pragmatic by saying a cash buyer hasn't met the obligation, then just move on?
I would say so, because what I usually advise is it worth you paying an attorney a very high legal fee in order to get a certain commission amount, depending obviously on the value of the commission. Because if the commission is like something over 200,000, then I would say pursue it. But if the commission is less, then I would say, you know what, I'd rather move on, because all the application itself is going to be expensive for you. So that is why, again, if it's a cash buyer, I would always ask for proof that the funds are available.
Yeah.
Just like we do a
Yeah.
pre-approval for those who are applying for a loan for a cash buyer, then I would ask for, like, they must provide me with proof that their money is there, is available. It's sitting maybe at a certain fixed account or whatever.
Yeah, a long time ago, some of our older team members, we would have discussed this, but a cash buyer does not impress us. Only proof of that cash and cash in the bank, ultimately, or in the conveyance's bank account, is actually worth anything. Other than that, it's just talk.
Yeah, true.
I've seen it not work more than it does work.
Yeah, true.
Good questions so far, guys. Any further questions?
Hi, Phatheka.
Hello.
I just wanted to ask, because we're still new in the journey, some of us, at what stage would you want us as the practitioner to get you as the conveyancing attorney involved? Would that be before the OTP, or would you want to look at the OTP first to see how it's documented?
I've got the copy of the OTP. David did share it with me. I think what is important
Okay.
is to engage your conveyancer like from the onset, whereby if there is something to be clarified, because remember that the OTP as it is standard, there are certain clauses like what I did today. I selected a few things that I know that are always burning issues, or issues that I always get as questions. So if there is something that needs to be clarified, is to say, do not shy away from calling and say, Phatheka, please do check clause number what. The seller wants to know, what does this mean? So meaning having to engage your conveyancer is from the onset. When I mean onset, then I mean, obviously, if there's something that you yourself do not understand, then that's when you can say, okay, Phatheka, can we go through this? I just need to understand something. Because you must remember that there are those that are obviously regular sellers or regular buyers, those that are dealing with property, and they understand all these terms. There are those who do not understand at all. And there are those that are kind of like ignorant, in which you have to help them to understand so that they don't misunderstand anything and cause the deal to either fall through or delay.
Okay.
Yes. Thanks, Lebohang.
Can I recommend everyone who is on EXP go through the EXP documentation, the mandate and the offer to purchase. Please spend time going through it, and then highlight any queries you have. And we can either have a one-on-one with Phatheka, or otherwise we call Phatheka back on at another stage in a week or month's time, and then we go through a Q&A on an offer to purchase document. So
yes, thank you.
And we can definitely do that. Well, I'm not presuming that Phatheka will allow us a valuable time, but I'm sure she will assist. But yeah, it'd be nice to have
definitely, David.
Yeah, we are listing, but please go through that documentation. It is our responsibility. A lot of our training, or most of our training, is on lead generation, which is critical for our business, which is the lifeblood of our business. But once we actually are, now that we're going after the dog, or the dog going after the bird, now the dog's caught the bird, what do we do with this thing? We've got a buyer, what do we do with it? And that's where the offer to purchase comes in, and the documentation. Where you got a seller, that's where the mandate comes in. Please do your research. Please go through that documentation, and then highlight the queries that you may not understand any of it, or you may understand all of it, or anything in between. And then we can set up dedicated Q&As on that. But that is your responsibility as the agents team. Okay.
Yes, thank you, David. Yes, that's correct.
Cool. Good. Any other questions, guys?
Hi, Phatheka, David, and team. Sorry, I'm joined very, very late.
Hi, Clinton.
So I actually had a meeting now with somebody that's putting an offer in for one of the properties that I've got, and it was together with her business advisor. And unfortunately, the last time I was meant to get a call from them, or they tried to call me, I was not available, and it was quite tricky to get the call back on. So they said 9 o'clock this morning would be a good time for them. So unfortunately, I took that instead of the training, but I look forward to getting the video from David. But yeah, thanks very much. And I've got no question. I just want to say thank you and apologies for stepping in late.
It's a pleasure. It's a pleasure.
Thanks, Clinton. Clinton was in the heart of it, dealing with a, I don't know, 4.5, 5 million deal, and going to the intricacies of the offer to purchase, because it's, there's quite a few parties involved, and obviously Clinton's got a lot of experience, but yeah, it does get a little technical, and but that's the heart of the business. When Clinton closes that deal, which hopefully is positive, I mean, it's a lot of commission.
Yeah,
you know, you're a third of your way to capping if you close a deal, as far as I know, something like that, a quarter of your way to capping.
Yeah, and it'll feel good beating Tam Golding agents, because there's three Tam Golding agents on it as well against with me. So if I can close it above them, that'll be great. Yeah, but it looks quite promising, and I'm engaging with the seller as well, so they've got an idea of what to expect. Yeah, but it's 4.7, and there's a bare dominium and a usufruct linked to it, so it's quite a US embassy purchase of another property. So there's quite a lot of complexity to the deal. So yeah, it took a bit longer than I expected, but yeah.
But you're really talking a language which is quite foreign. So yeah, but yeah,
Okay,
I mean,
it's not Greek, it's Latin, David.
Say again?
It's not Greek, it's Latin.
Oh, it's Latin. Okay, yeah.
Yeah.
I did Latin at school. Can you believe it? But yeah, those are the kind of technicalities. We're not going to go into the details of what bare dominium and all that kind of stuff, usufruct. But those are the kind of things that we pick up the phone to Phatheka or your conveyancer of choice. And this is why you need to have a partner that you can pick up the phone to. And it's not like you talk to them 5 days a week. It's that once in a blue moon that you get that technical OTP, that you can make that quick phone call or send out that email. Thanks, Clinton, and good luck for closing the deal. Okay, so any last questions, guys, before we close off in a minute? Would you like to close off on 10 o'clock sharp? But if there's any last questions, or otherwise we can close off now.
Can I go?
No, go
Okay, Phatheka, I'm so sorry. This is the last question, but I have a whole lot. So, I'm currently dealing with a new challenge, ne?
Yes.
I have a client, a South African, is married to an Ethiopian. So they were approved by FNB for 50%, of which they paid another 50% cash to the conveyance. So now the problem was on the husband, which is the foreigner, the name was misspelled. On the is it a work permit? On the work permit, and then it's not the same as the passport. It was misspelled. So now, when the bank asked for it to be rectified, they went to the embassy in Pretoria, but then they didn't win, because they said they should go and fix it in Ethiopia, of which it was impossible. So now we asked our conveyance, what can it be done? What can be done now? Since now we are on this stage whereby everything it needs to be finalized. I mean, the money is in, and then the FNB approved them, and there's nothing we can do. Can't we maybe do a temporal? But then the conveyance, what surprised me, the conveyance, like, she was clueless on what to be done. Of which I didn't take that like very generous, because I believe that you, as the conveyance, you need to advise us. As much as we're going to lose money, you're also going to lose money. Tell me, on that situation, what we would have done, because now the FNB is wants to cancel the offer to those people.
Okay, so the query with regards to the misspelled name is coming from the bank itself, right?
Yes.
Okay, so I think the tricky part here is that it's not something that can be done in the conveyancing office, for example. It's something that the client has to do. So meaning then the conveyancer should then be able to have a conversation with someone who does international law, whereby if there is a name that has been misspelled, then who actually issued the work permit, because it should start from there. Who issues that work permit? If it's issued, is there a way of us having some form of a confirmation? Because remember, it's the same thing as your own ID. If in your own ID there's a name that has been misspelled, they would want your birth certificate. They would want your parents to, maybe in the form of an affidavit, to confirm the actual correct name. because obviously most of the time Home Affairs do not want to take responsibility. So I think in this case, the conveyancer needs to speak to someone who is maybe in the embassy, because I think the embassy of Malawi is somewhere in Pretoria, if I'm not mistaken, so that they can understand what needs to be done. Because if it's something that is out of our control, then we need to do a research ourselves so that we can be able to advise you. Because I guess the most important thing is to be able to bring a solution to the problem. Whether the solution is going to take long, but we need to bring a solution to the problem. So they need to find out who issues it, and also in the event of the body that issues that permit makes a mistake, then what needs to happen, because that body needs to explain what is required in order for it to be rectified. So I think that's the most important information that the conveyancer needs to get in order for both, or for all parties actually to know if is it something that can be sorted without delays, or is it something that can be sorted but with delays.
Thank you, Phatheka. This is what I wanted, like Sarah. So now, if the deal is cancelled, you as a conveyancer, do you have any percentage amount to deduct from the client's money?
You know what? Obviously, we do charge for wasted costs. Then the tricky part is always on whose party is responsible for that bill. Because the wasted costs, because remember our fees are regulated. So we get our fees from the LPC, and then there is also a provision for the wasted cost there, what percentage, how far was the transaction, all those kind of things. But the tricky part is always who's now going to be responsible for that. Because in your case, for example, the party, the seller is not the seller's obviously issue that there is that there's that problem, and also the purchaser didn't know that there's going to be an issue with regards to the misspelled thing. So, but the most important thing is between the conveyancer and the purchaser, they need to find a solution.
Okay, all right. Thank you so much, Phatheka.
All right.
To me, it's a fantastic question. This is the kind of stuff we learn through examples. So, Pumi, you're allowed to have one or two more questions. If you do have, feel free to have it. And those that need to move on are quite at liberty. You're welcome to move on. But I mean, Pumi, if you want one or two more questions, use this opportunity to use it.
Yes, please.
Okay, I have another one.
Yes.
Okay, I'm dealing with how can I put it? With a difficult client. I don't think difficult is understatement, guys. So,
and the seller or the buyer?
The buyer, my darling, the buyer, that's the worst part, the buyer. So, the buyer bought a property from us, and then everything is with the lawyers now. But the buyer wanted the transfers to be very, very quick. So we told her from the beginning that the process, it takes approximately 3 months, but we will speak to our to the conveyancer
to try and speed, yeah.
Because obviously we have a relationship, but
Yes.
it is not in our hands. Now the problem is, while this house is in the process, it appeared that the sellers they had a shortfall. It was the first time I saw that.
Oh, okay.
Whereby they are not getting even a dime from selling their house. Instead, they have to top up and pay the municipality. So now the buyer wants to cancel the deal. Tell me, in your experience, is it something that she can do as the buyer? Because the conveyance didn't tell us that
there's a shortfall.
Yes, because the sellers, they didn't say they cannot pay that shortfall. But
you know what? Yeah.
Okay.
Yes, you can continue.
I don't know what I was gonna say, Phatheka, you disturbed me.
I'm sorry. Okay, no problem. You know what? In most cases, especially if you're dealing with a buyer like that, where the buyer is obviously kind of panicking because the transaction is taking long. And then again, there's a shortfall on the matter because, like I explained earlier, that when it comes to a shortfall, we have to get approval of that shortfall from the bank. And then also because you know, actually there are two options, because it's either the seller has money, then the seller can pay that money over for whatever the shortfall amount it is. Or we can apply at the bank to have that shortfall approved. Then it means that because the bank usually asks us to like a further document, asks us to prepare pro forma to show, okay, that from this we need to pay this and this and this and that, so that the bank then reduces the amount of the guarantee so that they can make money available to pay for rates and levies. So that's the purpose of the shortfall, so that the transaction can proceed.
Okay.
Firstly, the buyer cannot say that he wants to cancel, because obviously the cancellation part. But again, we need to be honest. In terms of our OTPs, again, it does state that the buyer can place the seller on terms, because it does state that the seller confirms. There's a clause that says the seller confirms that the purchase price covers everything. So meaning you confirming that the purchase price of your R5, it will be able to cover your bond, cover your commission, cover everything else. So the buyer can then use that in cancelling the deal, because the buyer can say that you did confirm that it is enough. Then what happened? But the most important thing here, because what I usually do in cases like this is you need to prepare the parties. So preparing the parties in the sense that make the buyer aware, because sometimes you will find, for example, I was speaking to a buyer yesterday. I said, you know what, I'm having difficulties in having the approved plans. The architect is giving us a runaround. So unfortunately, we haven't paid transfer cost. The seller doesn't have money. So if you pay transfer cost, I can use your fees to appoint another architect and get that architect to quickly do whatever that is required, so we can have the deal to move forward, because both parties are still willing, the buyer willing to buy, the seller willing to sell. So meaning if you pay the transfer fees, I can use my transfer fees to get the architect, because the seller says he doesn't have money. So it's just a situation of make everyone involved in the transaction, so that you don't run along with the property practitioner or run along with the seller and leave the other parties outside. Run with everyone so that everyone should understand. That is why, again, the importance of having updates on a weekly basis to all the parties, so that we should foresee the delays as conveyancers and be able to advise the parties, guys, there's going to be a delay because of 1, 2, 3, and also try and see if there are solutions with the delays and get everyone to be involved in bringing the solution.
Okay, all right. I get you, Phatheka. I get you. Thank you so much. And another thing that I have a problem with you guys is conveyance. I'm including you, Phatheka, because you're also
Yes,
a conveyance.
yes,
Is the fact
yes.
that when you have updates, you do not send it to us as the property practitioner. You are sending it directly to our clients, forgetting that those clients, we are the one came with those clients.
They were brought by you. That's correct. Yes.
Yes, I really have a problem with that, and I've been communicating with it. I'm also communicating it with you as well, because you will never know I'm gonna work with you. You do not
You know what? It's
tell
always
before
yes.
telling
No,
me.
I agree with you, sis. I agree. But it's always important, because remember, one thing that has always been my motto: I don't want a client to be calling me for update. So for me, it's always a situation avoid that by all costs. When I say client, then I'm including the property practitioner, I'm including the seller, I'm including the buyer, because all these parties, they want to know why there's a delay, or how far the process is going to take, or have you received this, or whatever it is that they want to know with regards to the transaction itself. So all parties that are involved in that transaction, that is why even acknowledging receipt of the instruction, the property practitioner must be involved. We need to acknowledge receipt with them as well, so that they can get the updates as well.
Yes, thank you, Phatheka. It's really, really embarrassing when my client call me and say, no, Phatheka said this, whereas Phatheka didn't say this to me. Like, you don't even know what to say to your client now, because now she has the information you do not have. It's like now you are incompetent.
No, true, because again, you don't want a situation where I don't know what you guys were discussing in the initial stages. So it's important. It's like if there is a problem, I have to speak to you first and find out, do you know about this problem? So we can discuss it together to see if there's a way of trying to obviously mitigate, because the most important thing here is the transaction must be finalized or must be concluded on time.
Yeah.
So that is why for me inclusivity is always the best, because everyone should be part of the transaction. If there's a delay, everyone should know about the delay and everyone should bring a solution to the delay.
Yes, thank you so much, Phatheka. You have a great day.
Thank you so much, Sisi, and thank you for all these questions.
Fantastic, guys. That's been awesome. So I think we need to, it's well over time, but thank you, Phatheka, for not only extending your time with us now, but also for the time that you invested with us. And hopefully we do good business with you. And guys, the details are here. Please be in touch with her. And guys, thank you so much for everyone for attending. And we're here to assist in any way we can. And in the meantime, keep going onwards and upwards and keep persevering. Thank you, everyone.
Yes, thank you so much, David. And also, oh, sorry, David, sorry. And also, I know that most of the time someone is going to call me and I'm not going to be able to take a call because we sometimes have meetings like throughout the whole day. It's always best to just leave a voice note on WhatsApp. Phatheka, I have this issue, and then I will voice note you back. It just makes it quicker then, so that I know that should it be, unless obviously something that requires like a discussion. Then if it requires a discussion, yes, then we'll have to set up an appointment. But if it's like a quick question, then yes, you can leave a voice note, then I will voice note you back.
Perfect. I love that. Great strategy to use. I think that works. Thanks to everyone. Chat soon. All the best. Hey?
Thank you so much, David, and thank you so much, guys. Have a nice day. Bye.
Bye.
Thanks for the session. Bye.
It's a pleasure, guys. Thank you. Bye.
Bye.